Well, good morning, everyone. Thank you for joining us with Massey University's Retail Reboot series. This is the 8th in that series, and the series is designed to help retailers and small businesses to adjust and thrive in the new economic environment. My name is Andrew Murphy. I'm a senior lecturer in retail marketing at Massey University in the Centre for Advanced Retail Studies. It's my great pleasure to host you all today, and in particular our two guest speakers. We have Stephen Lowe of Wynne Williams and Conor McElhinney from McGrath Nicol. Conor, I hope I pronounced your surname correctly. Stephen is a commercial lawyer and Conor an accountant, both with extensive experience in managing insolvencies, such as Pumpkin Patch and Topshop, among others, and a number of crises, including the global financial crisis and previous recessions that we've been unlucky to experience. Today, we're looking at restructuring tools for retailers in company law. So this webinar is looking at how businesses can navigate restructuring and changes in law that have happened as a result of the lockdown and physical distancing and the economic pressures that have been the result. So this links quite closely with webinar 2, which looked at the legal and lease considerations quite early in the process. That was when we were in lockdown 3, although that was only 6 weeks ago. A lot has changed since then, and we'll be hearing about some of those changes today. Just a bit of housekeeping before we get started. You all are on mute at the moment, at least you should be. Please do stay that way while the speakers are doing their thing. At the end, we will have a Q&A session, and you should have some time to unmute yourself then, if you wish, and ask an audible question. But if there's something that comes to you while Stephen and Conor are speaking, please use the chat box, put up your question, and they will be able to see that as we go. If you entered a question when you registered, Stephen and Conor have already seen those questions and will incorporate that into their presentation. So thank you very much, Stephen and Conor, and I believe we're starting with you, Stephen.
Thank you very much, Andrew. I've just started. I'll cover off what we're going to be presenting on today. So I'll be kicking off and talking about the legal changes that have been enacted in response to the COVID crisis. So I'll be covering off the changes to Property Law Act notices, changes to directors' duties, the new arbitration regime, and then just touching briefly on the debt hibernation regime that's been introduced. Conor's then going to cover the more interesting bit, which is the landlord and supplier negotiations and just where we're at with that and what you need to do to succeed in that. And he's also going to cover off the other restructuring tools that are available to retailers under the Companies Act. So on my first bit of these legal changes, I should say that the government did rush some legislation through dealing with directors' duties, PLA notices, and debt hibernation in response to the crisis. The area of rent relief is only been the subject of a cabinet paper so far because of, I understand, some internal politics within the coalition. And so we're working just off cabinet paper, which is obviously hard for lawyers to interpret, but we'll have to see what the actual legislation says. So the first thing I'm going to cover are the changes to the Property Law Act notices. So the Property Law Act sets out a regime for how long a notice has to be given before a landlord or someone with a security interest can exercise their remedies in the landlord's case to terminate the lease and take possession of the premises, or in the security holder to exercise their powers of sale or enter into the property and exercise powers of sale. So the changes to those legislation are relatively straightforward. They only apply for a temporary period for 6 months after the expiry of the epidemic notice, which takes us through to Christmas Day this year. So during that temporary period, what's happened is that the period during which a landlord can terminate the lease has been extended basically by a month. So before a landlord can terminate, the rent has to be in arrears for 30 working days, and the landlord has to have given 30 working days notice to remedy the default. So they can be concurrent, so it's not 60 working days, but obviously there has to be a period during which the rent is actually in arrears before the landlord can give notice. So we've seen a practical example of this in the Herald this morning. Mr. Eccles of Eccles Coins and Banknotes he's down in the Dingwall building not far from here, has had his lease terminated. It looks as if his rent was in arrears for 2 months. and it's reported that the landlord offered a 15% discount. I don't know whether he agreed to it or not, but it sounds like he didn't pay any rent. So he is unfortunately in the position where his lease has been terminated. This notice period also applies to, it can apply to landlords if they own the property, or to anyone who's got a mortgage. In that case, the notice period before someone with a security interest can re-enter has been extended to 40 working days, up from 20 days. So in summary, what's happened is the government's added, in broad terms, a month extra. The effect of this, how does this benefit retailers? Well, of course, it doesn't stop the rent being payable. It doesn't stop the interest running if you've got debt. All it does is buy you another month's time to enter into a negotiation arrangement, or the type of thing that Connor will be talking about. So, I mean, it is a benefit, but all it does is really just buy you time.
And it is worth being aware that this does exist. We have had one client where the landlord issued a PLA notice when the arrears had only been in existence for 10 working days, and the PLA notice was only for 10 working days, both in contravention of the change of the law. So it was consequently an invalid notice as well. They didn't stop the landlord then trying to re-enter and change the locks on the premises, but it did when they subsequently got a letter from the lawyer advising that they were breaking the law and trespassing.
So I'll move now to the next legislated change, and this is the change to the directors' duties. And these are the duties which directors effectively owe to creditors. And I've set them out in the note here, but in broad terms, the duty of directors, which should be well known, is a director can't incur an obligation or permit the company to incur an obligation unless the director believes on reasonable grounds that the company will be able to perform that obligation. And the directors also can't let a business be run in a way that's likely to create substantial risk of serious loss to creditors. So they've always been part of our law. I should point out that actions against directors personally for breaching these duties are rare, because obviously you've got to prove these circumstances. But obviously the current crisis has given a number of directors cause for concern that they might be carrying on business in breach of these duties because of the economic circumstances they're facing. So the government's made some changes to this, probably in response to some concerned directors, which is a sort of an exemption. So the directors can continue to trade and to take on liabilities if the company is facing liquidity problems because of COVID-19, and the company was solvent as at 31 December 2019. And here's the trick: in good faith, the director has to believe that it's more likely than not that the company will be able to pay their debts on 30 September 2021. So it is a carve out from the traditional duty. I'm not sure that it is that much benefit. The common law certainly made it clear that even under the previous legislation, directors had a period during which they could reasonably assess the circumstances of the company and come up with a plan to resolve the company's circumstances, and that Connor will cover the sorts of plans that they could come up with. It is not the case that the minute you think you're not able to pay the debts, you're immediately in breach of your duties, and it never has been the law. So this is, in a sense, an extension to that carve out, but I think in a sense that the obligation to actually in good faith believe you're able to pay your debts on 30 September 2021 means that you really can't rely on the carve out without actually having a plan, whereas I think the current law is that you're allowed to have a period to formulate a plan. I think the new law actually requires you to have a plan. So I think personally, I think it's a limited benefit to directors. I think there was potentially some panic by directors as to what the current law meant. I don't think it was actually that necessary, but hey, it may comfort independent directors that you can point to this. But look, I think the key takeaway I would want to leave you with is don't think you can rely on that carve out without having a plan. And also you have to have already been solvent, and this has to be related to COVID-19. But yeah. Next thing I'm going to talk about is the proposed lease arbitration regime. This, as I mentioned, we haven't seen the legislation on this yet. It's just the subject of a cabinet minute paper, which has been published, and this is going to apply from 4 June for a period of 6 months. And what this does is implies a clause into leases of business that a fair proportion of rent and outgoings will cease to be payable when a business has suffered a material loss of revenue because of COVID-19. So I'm sure many of you will be aware that since the Auckland District Law Society changed its lease form in 2012, many leases have a clause 27.5 that actually covers this point and says much the same thing. And so if you've already had that in the lease, it's quite possible that you've already had discussions with your landlord about the abatement of rent that should apply in that circumstance. That test of what is fair is always going to be a challenging one, because it's not what's just fair to the tenant, it's also going to depend on what's fair to the landlord. So everyone's individual circumstances are going to be different. To sort that out and define what fair it means, the government has proposed there'll be an arbitration regime where the government will pay $6,000 per arbitration. I don't think that's personally potentially enough to sort out the dispute, but in some ways I wonder whether they shouldn't have just given the tenants the $6,000, but so be it. So there's supposed to be a regime to be worked through. We've yet to see the form of that. What is fair is apparently going to be expressed in legislation. We don't know what it is yet, although I'll talk about the Australian regime in a minute. And who is eligible? That's been the subject of internal negotiations with the government, but it's retailers with 20 or fewer FTEs per store, not across the company. So you look at a store-by-store basis. Importantly, it won't apply to an existing arrangement already agreed. So interestingly, our example I gave you of the man in the Dingwall building who was offered his 15% rent relief, I don't know whether he agreed to that. He said, presumably he didn't pay the rent, so presumably he would say, I hadn't agreed to it, I can still access this regime. But if you have agreed to it, then you won't be able to use this new regime if you already agreed rent. And the final is it only applies to New Zealand-based retailers only. So Australia has imposed a similar regime, so it's useful to look at that just to see what might be in the New Zealand one. They had a different threshold where your turnover had to be less than 50 million. Their regime contemplated that it would apply not just for the lockdown, but also a reasonable recovery period, that both that you can't be terminate the lease and also the rent abatement had to apply for a reasonable recovery period. We're yet to see whether that will be feature in our regime. And it was interesting that it was a minimum, although it was guidelines, not necessarily mandatory, it was expressed to be a minimum of 50% rent waiver and up to 100% of revenue lost. So, but with consideration of landlord and tenant relative strength. So Westfield have announced that they are adopting the above regime with their tenants in New Zealand. So, but we're yet to see what the actual legal regime is. Great. So the final legal change I wanted to cover off is the new business debt hibernation regime. I can only cover this in summary because it's quite a detailed regime, and I think Connor can speak to a bit more detail about it. But broadly, again, this is some help for retailers on a temporary basis. It effectively provides a 1-month moratorium that the retailer can go to creditors and seek and basically put a proposal during which this period creditors can't enforce debts or obligations. It doesn't waive the debt. There's nothing in the scheme relieves the retailer from the liability for the debt. It just is simply a deferral regime. And then during that 1 month, the proposal gets put to creditors, and if it's passed by 50% of creditors by dollar and number value, excluding obviously related party creditors, then there can be a further 6-month moratorium. And during that further 6 months, creditors can't take enforcement actions. So if the proposal is rejected, then it's back to square one, and creditors can take their enforcement actions, and Connor will take you through the different sort of proposals that you might then want to consider. So in broad term, how does this help retailers? It does buy some time. It definitely buys you potentially another month, which ties into the month I referred to on the Property Law Act notices, possibly another 6 months. There is a big carve out, which is that it doesn't apply to a creditor which has a general security agreement over the business. So that will typically be your bank. So you are not going to enter into this arrangement unless your bank is on board with you or whoever's got a general security agreement. So that is an important carve out. So the other thing you need to be aware of is that if you enter into this regime, as with the directors' duties, directors are required to certify that it's more likely than not that they'll be able to pay their debts on 31 September 2021, and the creditors can ask the directors to reissue that certificate every 2 months. So you would not enter this regime unless you had a plan, would be my takeaway from this for retailers. So that covers up the legal changes that we have seen, or which are coming up to help retailers. And now I'll pass over to Connor, and he'll take you through some practical issues.
Great, thank you very much, Stephen. So I'll cover off 3 areas: the landlords and suppliers, then I'll talk about the different restructuring tools, and if we've got some time at the end, I'll run through some research as well that McGrath has released on what's happening in the retail sector. So having a look first at the landlords and suppliers side of things, what are we seeing in the market? First of all, I just wanted to preface this and say that negotiation very much requires compromise, and it very much requires transparency. So in the first instance, it's very important whenever you're dealing with any of your stakeholders, not just your landlords, to be open, to be transparent, and to be honest. It'll require that you do share historical and forecast financial information so that they can see that you do actually need rent relief. And you need to consider what other stakeholders can contribute. So what can the shareholders contribute? What discounts can creditors provide? Are staff taking discounts in their salaries and wages? And are there any redundancies or other restructurings that are going on? You need to discuss what will happen to your business both with and without their support, so that you can understand from yourself and their perspective whether or not there is an incentive for them to assist you. And you need to be honest about what contribution the shareholders can make, if any. It's important to make sure that everybody is contributing to make this business survive COVID-19. This isn't an opportunity to make super profits by taking advantage of the situation and advantage of the stakeholders. And the reason I say that is because we have actually seen that as well in the context of retailers. We have seen, for instance, pharmacies in Australia who are seeking significant rent concessions despite the fact that their sales are in some cases double what they were in the prior year, and they're simply jumping on a bandwagon and looking to get rent relief on the basis that everybody else is. That's not what this is for. That's the first thing: be open, transparent, and honest. The second thing, of course, is be prepared, and this actually applies in any negotiation situation. But you should be modeling performance under various scenarios on a store-by-store basis. So nobody really knows what's going to happen to consumer spending in the next 3, 6, 9, 12, 24 months. Nobody knows. So you need to have high, medium, and low scenarios as to what you think might happen, and then think about, under those scenarios, what would we need to do? What stakeholder obligations might need to be restructured? What payments might need to be deferred? What discounts might need to be required? Do I need to change my employee structures? Would stores need to close or stay open? What would happen? And what could the impact be if you closed many stores? What impact would that have on the rest of the business? Does your business become too small? Do you end up losing economies of scale? And that was the case with Sierra Shoes, for example, when we looked to restructure the business prior to the insolvency. Unfortunately, the number of stores that had to close meant that the wholesale business then became uneconomical because we lost minimum order quantities and the costs of running a head office were too high relative to the reduced volumes that would go through. You need to think about what alternative options stakeholders have. So if, in the context of discussing this with landlords, their alternative option is to take back the site. So if you're going to offer them only 10% of their rent for the next 2 years, they'd be better to take back the site and let it to somebody else. So you need to be realistic about what it is that you're thinking about. And then based on the above, understand on that basis what it is that you need from the stakeholders to be profitable and sustainable, most importantly. So what are we specifically seeing? In the context of landlords, we're seeing a wide gamut of responses, from very generous and very helpful landlords to those who are unwilling to provide any compromise whatsoever, still demanding to be paid in full even during lockdown and issuing PLA notices. As we mentioned before, we had one who issued a defective PLA notice and even re-entered when there had only been 1 month's rent outstanding as well. Two, right at the other end, I've got another example where a landlord has provided free rent for April, May, and June, and only 50% rent payable for the rest of the year. So you can end up with this large divergence in what is happening with different retailers. Many of the larger retailers and landlords are actually still working out compromises, and as Stephen mentioned earlier, Westfield and Centre Group have publicly said that they'll adopt that Australian Code of Conduct and lease negotiations. So that provides you with a good framework if you're talking with them about what sort of things are potentially realistic. Stephen's already mentioned the commercial lease arbitration regime. So if you still haven't been able to solve something with your landlord, that hopefully will provide you with an opportunity. And then I'll talk in a moment about, if you can't get there through those sort of informal negotiations with your landlords, what other restructuring tools are available. You will have potentially heard in the media as well about what Solomon Lew, the owner of the Premier Investments Group, which is Just Jeans and Smiggle and those sorts of brands, they have about 1,200 stores, and they've gone to their landlords nationally in Australia and New Zealand and said that they'll provide 8% of turnover going forward, for instance, as an example. You may have seen that Burger King did a creditors compromise recently, and as a consequence of that compromise, Burger King and its landlords agreed that they would pay no rent for April, 25% of the rent from May to July inclusive, 50% of the rent in August, and 75% in September, and then start paying full rent again from October going forward. So those are two public examples that I can give you as to what sorts of things people are considering. But you also need to consider what the landlords would be willing to accept. Some of them definitely do not like percentage of turnovers. From their perspective, that provides difficulties in valuations of properties and uncertainties with regards to banking covenants and meeting banking covenants going forward. So you need to think about those sorts of factors too. From a supplier's perspective, this is very much a case-by-case basis. The most common that we are seeing with suppliers is deferrals, extensions to pay, so time to pay arrangements. And often we are seeing very commonly as well, discounts on future orders. So a lot of future orders have been placed, as you know, being retailers, it takes a long time to get a season into the stores, and it is quite possible to have discussions with your offshore suppliers and change those orders or seek discounts. And usually what we're seeing is that a retailer may go to that person and say, that supplier and say, look, we're not going to need as much as we thought we were going to need. So we would like to reduce our orders by 20% or 30%, whatever it happens to be. Or alternatively, can you give us a 20% discount going forward? And those are the sorts of numbers that we're seeing as well. It's important to remember that this is very much a global issue for manufacturers. This is not a New Zealand issue by any stretch of the imagination. You know, we've got our manufacturers in China and Indonesia and India and everywhere else are supplying retailers around the world, and New Zealand is a small part of that. And you may have seen the sorts of things that are coming out in the UK with fast fashion retailer Peacocks, for instance, refusing to pay its suppliers for any future orders, including for stock that had already been handed over. And you've got the Topshop owner Arcadia refusing to pay for $2.5 million of orders with its key supplier of jeans, for instance. And then you get the opposite end of the spectrum. The owner of Ben Sherman is advising that they are paying all of their suppliers in full, but simply on a deferred basis as they get their money in from retail. In these sorts of examples, it's the manufacturers that have less power and the retailers that have more power, because those are big retailers and those manufacturers rely on them. But that's not the case in New Zealand. It's likely to be that you are not a big part of their sales function necessarily, and consequently, again, the balance of power of negotiation is different. It's also important to remember that there are very different language, cultural and legal barriers to contend with. Trying to explain to a Chinese supplier the New Zealand creditors compromise regime and how liability works is an exercise in futility, and wouldn't recommend it. And it's also important to remember the other options that they have. So there is, of course, the Chinese government provided trade credit insurance. And so they could simply stop trading with you and call on the trade credit insurance instead and have their funding. Now, there is a downside to them in doing that. They get a red mark against themselves and they can't trade with you going forward. And an example of the compromise that suppliers have provided in the Burger King case again, the creditors here were suppliers of food and other services, so Fonterra, Coca-Cola, Ingham's, McCain, things like that. They were owed collectively about $10 million, and they voted to agree to provide Burger King a 25% discount on what was already owed, so a $2.5 million discount, with the balance of $7.5 million to be paid over 8 months. So that's an example of the sort of compromise you might be able to reach with a supplier. If you can't reach informal compromises, so if you can't informally agree with your stakeholders by having discussions with them, your landlords and suppliers, what you need to do, then instead you may need to consider more formal restructuring tools. And that's what I'm going to have a chat about now. What kind of tool you're going to use depends on the level of distress of a business. So if you're in a low level of distress, if you had a good business before coronavirus, if your creditors generally were up to date beforehand, your ID was up to date, but you've suffered this temporary cash flow issue as a cause of lockdown, then probably where you're going to lean towards is these informal negotiations and restructurings, perhaps supported by an independent expert to give weight and credence to whatever it is that you're telling them. The reason I've got performance improvement marked as red on this is because performance improvement does not solve short-term issues. Performance improvement will take many months to have an effect on the business, and so if you have a cash flow issue now, it won't resolve that. The business debt hibernation regime can provide you that short-term moratorium from 1 to 7 months, as Stephen talked about before, and I'll talk a bit more about that in a moment. If you're in that kind of medium distress camp, so you've got limited free cash, There are a bunch of age creditors, there might be IRD arrears as well, and there may potentially be a risk of creditors taking action against you. They might issue statutory demands or property law act notices. If you do not need any protection from statutory demands or PLA notices, or from people repossessing stock, then a creditor's compromise is the best regime to use, and I'll talk about that regime shortly and why that is. But if you do need protection, so if in the case of the coin and banknote person, he could have appointed a voluntary administrator, and a voluntary administrator would have prevented the landlord from re-entering the premises. It would have preserved those premises for the business going forward. And you could also, in the short term, again, use business debt hibernation if you do need protection. If you're in the category of high distress, so you don't have enough cash to pay wages or rent next month, even though the government is paying your wages for you, at least to some degree at the moment, or you've received some statutory demands already or PLA notices, or you've lost the confidence of the bank in particular, that's a big issue, then if there is a part of the business, a small part of the business that might survive restructuring, you may still consider voluntary administration, but more likely at this case, the horse has already bolted, the business is too far gone, and you're more likely to end up in a receivership or a liquidation scenario where the business ends. So again, they're marked red because they don't restructure a business, that's the end of a business. So talking more about the actual restructuring tools that we talked about, business debt hibernation, which Stephen's already covered off, when should it be used? Again, it's only when the company is temporarily impacted by COVID-19, and otherwise it's a viable and successful business. You need to be able to pay all of your debts at the end, and you may need protection from creditors from statutory demands or PLA notices. That's the only reason you would use it, because it provides that temporary protection. Key pros, it's very quick and simple. It's cheap, you can do it yourself. There's a guide on the website that we provided a link earlier, and it has a low voting threshold. You only need 50% in number and value of your creditors to vote in favour of it to provide you that moratorium period. On the downside, though, it doesn't actually remove any debt. So where Burger King is only paying 75% of what it owes to its suppliers and is paying less than what it owes to its landlords, you can't do that under business debt hibernation. You still have to pay 100% of your debts. And it doesn't apply to employees and banks. So very, very much the key takeaway here is it is debt deferral only. You need to be thinking about how you will pay all of your creditors at the end of this in 6 months' time. Are you going to generate enough cash and profit in the next 6 months and working capital to be able to restart and pay all of this back? The business debt hibernation regime definitely will not save a business that was struggling before coronavirus. The creditor's compromise, on the other hand, that can be used for businesses that may have already been suffering to some degree prior to coronavirus. It is a formal agreement under the Companies Act, under Part 14 of the Companies Act. It avoids a receivership or a liquidation because it effectively agrees to compromise all of the debts with counterparties, and you can do it for almost any purpose. You can have almost anything in the deed of the compromise that you want to. You can use it to get out of onerous contracts, such as a retailer exiting unprofitable stores. You can use it to repay creditors less than what they're owed and or over a longer period of time. And that is exactly what has happened with both Burger King and with Max Fashions, which you would have seen in the media over the last few weeks as well. The key features of the regime are that there is no public notice, although given that you will have read about it in the media, leaks do happen, unfortunately. There is lower reputational risk than going into a formal insolvency because it is a restructuring regime. And very helpfully, the legal entities remain whole and the directors remain in control. With the other options I'm going to talk about shortly, if you choose the other options, you lose control. I take over. As the insolvency practitioner, I come in and take over. But in this one, you stay in control. In order to have a compromise succeed, you need a majority in number, so more than half in number, representing at least 75% in value of the claims to vote in favour of it. So it's quite a high threshold, 75% in value of claims plus at least 50% in number to get over. And once it is approved, it's binding on all creditors who receive notice, including those who voted against it, if you get over that threshold. But there is no protection from creditors. So creditors can still, until the compromise is approved, issue statutory demands or PLA notices or go after personal guarantees or anything like that. There isn't any protection from this regime until and if it is successful. How does it actually work? In the first step, the directors are usually the ones that will consider that they need to do something. They will approach a compromise manager, which is somebody like myself from McGrath-Nicol, and that experienced independent party will be the one that guides them through the process and supervises the compromise itself. The idea is to develop a compromise plan to work out what is the assistance that you need from the stakeholders and how will you approach that, which creditors need to be compromised, how much will be paid and over what period of time. Typically what you will do is then sound out the proposal with key creditors to get buy-in in advance. So that's what we did, for instance, on Max Fashions. We went and spoke with a number of the large key landlords to say, look, this is the situation, this is what's required, is this something that you would support? And had they said to us, no, we won't support something like this, then we wouldn't have even bothered launching a formal compromise. The business would have gone straight into receivership instead. So you go and sound out the proposal with the stakeholder and see whether or not they will be supportive. If they are, then of course you formally notify the plan to the affected creditors and launch it, and then you have the vote. If the vote is rejected, you can theoretically go back and try and launch another compromise, but that's rare. Usually what you will have done is put forward your best foot forward, the best proposal you could possibly do, paying the most you possibly can to people, and if it is rejected, more than likely what will happen is that you'll end up in receivership or liquidation or some other form of insolvency like voluntary administration. If it's approved, however, then the plan is implemented and under the supervision of the compromise manager. Creditors can vote at this meeting by postal vote, so you don't actually have to have a physical meeting at all, and that's the most common way, is people just post in their votes. And you have to be given a minimum 5 working days notice for that as well, and a copy of the plan does get filed at the company's office, and that's how leaks happen as well. If a disaffected creditor doesn't like what's happening, often they'll just pick up the phone to the media and say, you should have a look at the company's office website and have a look at this document. So it is technically a public document. Anybody can go to the company's office and look at it. So you do need to bear that in mind, but somebody would have to know about it to go and look at it. When should you use a creditor's compromise? Ultimately, the company needs to be viable overall, but it needs to have just incurred these losses or built up creditors due to this one-off event that isn't going to reoccur going forward. There's no point in compromising creditors now for a bad business that's going to continue to be bad going forward, because it's going to end up in the same position. It only works where the value of the company's assets is actually less than its debts and claims too. Otherwise, from a creditor's perspective, you would just say, well, no, liquidate the company and pay me in full what I'm owed, rather than compromising me. And you do need to have good relationships with your key creditors. If you've burnt your bridges, they won't vote for you out of spite. And so they'll see you go into some form of insolvency, even though that may not be in their financial best interests. It can be helpful if you need to protect some key contracts, because it may not necessarily be a breach, although it is important to check that. And it's useful if you don't have any immediate threats from creditors issuing statutory demands or PLA notices, so you don't need protection from them through the moratorium that you can get in other tools. And if you want a private restructuring, and of course the bank must be supportive. Key implications for directors is that they remain in office with full powers. So you guys keep running the business through all of this. You've just got the advisor separately helping with this specific process, but you're still in charge, still running the business. But during that time, as I mentioned, there is no protection from enforcement of personal guarantees before the compromise is approved, and there isn't any protection from insolvent or reckless trading claims either until the compromise is approved. But this is exactly what Stephen was mentioning earlier about people have a reasonable period of time once they've realized there's an issue to go in and develop a plan and try and solve it. You don't have to, the day that you realize the business might not succeed, immediately put it into insolvency. There's a period of time where you can try and restructure it. And this is a sort of tool that you could use to restructure it. So on to a voluntary administration regime. What is it? This is another part of the Companies Act, Part 15A of the Companies Act. It does effectively a similar sort of thing to a compromise. It's about reorganizing and restructuring and refinancing a company as well. Officially, the objective is to maximize the opportunity for all or part of the business to continue. Or if that's not possible, then at least to develop a plan to sell the assets of the company and get a better return than you would otherwise get from an immediate liquidation. Ideally, the outcome of a successful voluntary administration is something called a deed of company arrangement, or a DOCA. That is basically the same as the compromise deed that we talked about before. It's just in a different name, written in a different way. And it also is a contract, an agreement between the business and its creditors as to what you will pay them over what period of time and what else is going to change within the business. In terms of the key features here, it doesn't require a court application, so directors just appoint, and it does give you breathing space. There is a moratorium. Once you're in voluntary administration, creditors can't take action, they can't come and repossess stock, they can't kick you out of stores, all that sort of thing. And it provides a very orderly, transparent process for this thing. It preserves enterprise value and employment and hopefully supplier relationships, and creditors are dealt with in terms of that DOCA. It does always require lender support again. Bank support is very important. So a good example of this sort of voluntary administration is Sumo Salad in Australia. And effectively what happened there is McGrath-Nichol assisted the company to pull together a restructuring plan to restructure its stores, which are salad bars within a lot of the malls type stores in Australia. The issue with the business was that sales had been falling as footfall to the malls was falling, and as the closure of retailers was being replaced with more and more food outlets. So their competition was increasing, footfall was falling, revenue was falling, but rent was increasing every single year with those ratchet clauses that I'm sure you're all well aware of. So we went to the landlords and said, here is a restructuring proposal that is required in order to make this business viable. Please support it. And the landlord said, no, we won't. And we said, well, if you don't, then the company will go into insolvency. And they said, we don't believe you. And so then the company went into insolvency, into voluntary administration. We then went back to the landlords with the company in voluntary administration, saying to them, here is the same proposal, now called a deed of company arrangement, less the costs of the voluntary administration process. If you agree to this, this is what will happen. If you don't agree to this, then the business and assets of Sumo Salad will be sold to somebody else. And through that business and asset sale process, all of the liabilities will be left behind. So for those closing stores in particular, you'll get nothing. And in that context, the landlord said, okay, clearly you guys were bluffing. We will vote overwhelmingly in favor of that proposal. So that's a good example of a voluntary administration and a DOCA being approved and saving a business. On the other side, Ziera is a good example of the second objective of a voluntary administration, which is if it's not possible for a business to continue, then trying to sell the assets for the maximum value. So again, the directors here considered the restructuring options. Unfortunately, the business wasn't going to be viable. Even with good concessions from landlords, it still would not have been viable. And so the directors elected to effectively wind up the business, appointed us as voluntary administrators, which enabled us to trade the business in Australia and New Zealand without landlords coming and taking over the sites, and therefore enabled us to sell all of the shoes and also run a business sale process and sell the business as a going concern, which overall maximized the return for the creditors. So there's in this case, the bank being repaid in full and the unsecured creditors of Ziera Wholesale New Zealand getting about 60 cents in the dollar, and the retailers getting about 25 cents in the dollar, which is considerably more than is normal. So how does a voluntary administration work? Normally it's the directors that appoint a voluntary administrator, but theoretically the bank or a secured creditor, a liquidator or the court can also appoint. Once that happens, the creditor's rights to commence or continue enforcement proceedings are put on hold and they can't do anything. You've got that breathing space. And the administrator, so that's me, becomes personally liable for the day-to-day trading of that business. Every liability that's incurred from the date that I'm appointed, I am personally liable for. And if it doesn't get paid, it's my neck on the line that ends up having to cover any shortfall if there was one. At the first meeting of creditors, which happens within 8 days, you vote on whether or not to replace the voluntary administrator or keep the voluntary administrator and whether to form a creditors committee or not. And during that time period as well, or during 10 working days, the secured creditor can actually still appoint a receiver if they want to over the top. Then you move towards the watershed meeting. At the watershed meeting is where the creditors actually vote on this DOCA, this deed that we talked about before, which is the restructuring of the business. And hopefully what you've actually done is prepared the DOCA before you get to that point. Ideally, what you do is actually prepare a deed of restructuring before you enter into voluntary administration, because the time periods are actually very short and it takes a lot of time to work out how to restructure a business. So ideally, you would have done that in advance and then appointed. If the DOCA is approved, then it is binding on all creditors. Again, it requires the majority in number and 75% in value to pass. So, and every creditor votes. In a creditor's compromise, only those people that you send the compromise to vote. In this, every creditor votes. So it's a much broader, more expensive, time-consuming and costly regime. And if creditors reject the deed of company arrangement that you've put forward, then either the company is placed into liquidation, or in incredibly rare circumstances, the company is actually returned back to the directors, but I'm only aware of that happening once in New Zealand. So when should you use a voluntary administration? When the business itself or part of the business is viable, but it needs to be restructured. Again, where the assets are less than the total debts and claims, where you need protection from creditors who are threatening to take some kind of action in particular, and where you might have the bank suggesting that a receivership is necessary, but maybe a voluntary administration might provide a better outcome for all parties. It also happens when directors are the ones that want to be seen to be in the driving seat, where they want to take action to a point. And usually it applies more to larger businesses, although it is certainly used still by smaller businesses because of the costs of the process. In terms of the implications for directors, directors have to prepare a statement, a formal statement of the business, property and affairs within 5 business days, although that can be extended. Directors remain in office, but all of their powers are suspended. So effectively all the power of the directors transfers to me and my co-appointees, and then we run the business going forward. But you are protected from enforcement of personal guarantees during the administration anyway. And you're protected from insolvent or reckless trading claims, provided you weren't trading whilst insolvent prior to that, and you do have to attend the watershed meeting. So that's the VA regime. What about the last 2 tools, the receivership and liquidation side of things? These aren't really restructuring tools. These are end of life, end of business tools. And most often they do result in the end of a business. And these are on screen, just some of the examples of the businesses that have gone through these processes and sort of cease to exist, but I will highlight a couple that don't. Pumpkin Patch and Dick Smith are good examples where it was actually both in receivership and in voluntary administration in order to get the moratorium from landlords. Here, the intellectual property was sold. So the brand, the customer databases, any of the designs and what have you were sold to counterparties. But none of the continuing business, none of the stores, none of that carried on trading. So effectively still what we would call the business, what you would imagine as the business, the employees and the stores and everything else, that ceased to exist. In the case of PK Furniture and Shoe Connection, those were related party sales. So here are a couple of examples of businesses that did sell out of insolvency, but to related parties. So PK Furniture was bought by the managing director, but he only took on some of the stores, obviously, and Shoe Connection bought by the son. And Smith City, most recently, of course, you will have seen, same thing, sold via what we call a pre-pack receivership, whereby the sale process was undertaken before it went into insolvency, and then the purchaser has bought all but a few of the stores which will be left behind in the insolvency. So that's the end of companies in terms of restructuring tools. So I think we do still have time, so I will run through the numbers. What have we seen in the numbers? So McGrath has been releasing some research during the coronavirus period, which we intended to help retailers and stakeholders within the retail industry understand the impacts of COVID-19 that might therefore help in negotiations between stakeholders as to what you need to do and to consider and plan for what might happen in the future. So we looked at a few things. We looked at what happened before the lockdown, what happened in previous crises, and then what happened during the lockdown. All of this research, if you want to get into it in more detail, is available on McGrath website, and we can provide links later. This first chart shows foot traffic in New Zealand, in the North Island and in the South Island. And it shows foot traffic from January through to the end of March on a weekly basis. And what you can see from those black bars is that in the North Island, footfall was falling before lockdown. In the North Island, traffic was down 10 to 20% from January to March. And in those last 3 days before lockdown, it was down almost 80%, both in the North Island and the South Island. So in other words, retailers were suffering from reduced footfall and lost sales before lockdown, not just during lockdown. And this, of course, impacts on the profitability and viability of retailers as well. We presume that this is linked to the business confidence, which has been hammered for some time in advance of coronavirus. How did that translate into spending? This is the Paymark spend, which we get from MarketView, who kindly provide this to us for free. This is in-store spending only, so it excludes online. So we're looking just at what's happening within the retail stores. And as you can see, these different bars are, the first bar is the 4 weeks ended March, so basically February and then the first week of March. And then you can see each of the individual weeks, week ended 15th, 22nd of March, and then the 3 days ended 25th of March. And as you can see, some sectors benefited and some sectors suffered significantly. Apparel, hospitality and accommodation were the most heavily affected. You know, sales were down over the whole of March, and they were down over 50% in that period prior to lockdown. So when people and stakeholders in the industry talk only about the lockdown period, they're missing that there is a broader impact here. On the flip side, there were a number of retailers who benefited greatly from this. Preparations for lockdown caused liquor sales to be up 5-fold compared to what they would normally be. It's telling as to New Zealand's mentality as to what they need to prepare for. I think they spent more on liquor than they did on toilet paper. And they were also spending and preparing for working from home. They were buying computers, laptops, and screens, as well as spending for home improvement jobs. I would love to know how many of these home improvement jobs actually got done, but the spending was up 3-fold almost on hardware, building and garden supplies immediately prior to the lockdown. So I don't see a lot of new gazebos around my neighborhood, that's for sure. So there were some winners and some losers. So depending on which category you're in, depends on whether you need to negotiate with your stakeholders for compromises. You know, if you are one of the ones who has actually had great sales, even better sales than you had before, then seeking rent relief is not going to be fair and reasonable. What's happened in past shocks? This is what happened during the Asian financial crisis, the dot-com bubble, and the GFC for each of the sectors. And as you can see in past shocks, the hardest hit sectors were those that are linked to property and construction and large capital expenditure. So hardware, building and garden supplies fell 43% over the 2 years following the GFC. And furniture, floor covering and textiles started their decline shortly after and fell about 20% through that time. Motor vehicles and parts retailing was also significantly hit, down 27% over 18 months. And it's important to note that actually motor vehicle retailers were already hit from January 2018 to now. Prior to coronavirus, sorry, there was already a significant drop-off in both used and new car sales in New Zealand. Those that suffered the least were food and beverage services, accommodation, apparel and pharmaceutical and supermarket retailing. This time, however, is different, of course. Food and beverage and accommodation have been severely impacted by the total shutdown of international tourism and originally also by physical distancing. And of course, pharmacies and supermarkets have actually benefited on the flip side. Apparel is the hardest sector to predict, and I'm not sure where it will go. In past sectors, you can see it's only been down 5%. But in this sector, and this shock, we're wondering whether or not, given the level of GDP impact, given the level of unemployment, which is shown on the second chart here, that there will simply be less consumer spending available. And even though people may, on the one hand, maintain spending on smaller discretionary items like a new item of clothing and a coffee and things to make themselves feel good, and instead not do the big discretionary items like the new gazebo or car or TV, this time there may still be more of an impact than there was in the past. And our UK colleagues are predicting a 27% decline in apparel retailing in the UK as a result of coronavirus. What happened during lockdown? So here's levels 4, 3, and 2. This is the footfall in New Zealand, passers-by and inside. What you can see from the data is that consumers are being much more targeted with their trips to store. So passer-by footfall was down more than in-store footfall. And we actually see in the spending data as well that there are fewer transactions, but at a higher value. So people are going to specific places to buy specific things and spending more when they do get there. Inside footfall and total retail spend did bounce back, as you can see, to slightly higher than prior year levels in the first week of trading, and perhaps, of course, as consumers caught up delayed spending. In the second week, it started to drop off. We only have the first 2 weeks of level 2 there at the moment to talk about. In this second chart, you can see again, it's the spending by particular subcategory, and you can see the pre-lockdown levels 4, 3, and then level 2, week 1, level 2, week 2. And again, you can see that it's a very different story depending on the subsector. So while total retail spend has bounced back, and the high-level numbers are reporting that the total retail spend has bounced back, you can see that hospitality, fuel and automotive are still down 20%, even with the relaxation of distancing in level 1. We still consider that sector will be down in the coming months due to a lack of tourism. And most other sectors have enjoyed very much a bounce back as people trapped in their homes were finally allowed out to go and do something different and buy something new. But we would very much caution looking at this data, this short-term data, as any indication of a return to normal or even a new normal, given those economic consequences of COVID-19 we saw on the previous page aren't yet really fully impacting consumers. The redundancies, the lost income, the impact on GDP are all really to come. And you can see, of course, just between the first and second week that already there is that reduction. It's still up, but it does look like a peak that is coming off. So the other key message there that is very, very key, very important that you look at the data for your specific sector and even your specific region. It's different within CBDs versus suburban outlets as well. So that's a very quick run through the research that we wanted to cover off. Thank you very much, Andrew, for hosting us. If there's any questions, I know there's a couple that have been written in advance. I'm happy to answer.
Yes, thank you very much, Stephen and Connor. It's excellent detail there, and I really appreciate you taking the time to walk us through that. As I mentioned at the beginning, there are 2 questions that were posted through the registration process, and we've put them up in the group chat. So if any of you have questions that have come to you while Stephen and Connor have been speaking, now's the time to put them into the group chat. But I'll ask the 2 of you to take a look at the 2 questions that you have already seen, and you have already given us some information about those questions already. And I have a couple of questions to pose to you as well.
Okay, great. I can see the question up there. So the first one is, with the rapid digitization of the retail industry giving consumers an opportunity to purchase in the international market, what steps will a local New Zealand retailer need to take to protect their market share? That is a very good question. Digitization is an ever-increasing feature in retail. It's a year-on-year factor. It's not new from COVID-19, but COVID-19 might certainly have accelerated it. It might have taught a few people to learn how to digitally shop that they didn't know before. So, in fact, what we have already seen is that New Zealand retailers very much need to have an online presence that's at least as good as their offshore competitors, and they need to, in order to protect their market share. And we've seen that happen. So New Zealand retailers were losing market share to offshore retailers and had been losing market share for many, many, many years it had fallen from 63% of online sales being to domestic retailers in the mid-2013 down to 56% of online sales to domestic retailers by mid-18. But at that point, it shifted, and New Zealand has started to claw back. From mid-2018 onwards, domestic retailers have actually built their web presences up, and they've clawed back market share in the last 2 years, which has now grown from 56 to 59% and shows no signs of declining. And a good example of that is Xero, for instance. Xero did not launch their online website until the end of 2017. They thought that online wouldn't really suit their customer base. It turned out it did, by the way. Online sales in Australia made up 22% of their revenue, and in New Zealand 11% of their revenue, so it was very much important to have it. So New Zealand retailers, make sure you've got a website, but we can already see that you are doing that, which is great, and you are pulling back market share from international retailers. Second question I can see there is, what sort of deals are we seeing being done between landlords and tenants where tenants are still experiencing a downturn in turnover after lockdown? So how are landlords and tenants viewing rent relief when the pain of COVID-19 lingers, but the legal obligations of ADLS 27.5 only deal with the lockdown period? And that's a great question. It does only appear to deal with the lockdown period. And you compare that to the Australian Code of Conduct, for instance, instead, which says that it applies also for a reasonable recovery period. So what's reasonable? Being open, transparent, and honest, and sharing that information with your landlord is key. And it requires you to consider both the financial position of the landlord and the tenant as well. So if the landlord is actually highly geared and not in a position to service its debt without support from the retailer, and the retailer is cash rich and asset rich, the retailer should theoretically continue to pay in full to support the landlord, oddly. In New Zealand, what we're doing is we're seeing landlords that are very willing to compromise on the specific lockdown period itself, and some are willing to consider compromises for the few months thereafter, but there is very much no consistency. I already mentioned some examples as to what we've seen before, and that's where a creditor's compromise comes in, because it treats everybody, it forces everybody to be treated equally as well. And remember too that some tenants have actually done very well out of COVID-19. Even though they may have lost specific trading during the lockdown, there were significant peaks before and now after that overall have probably put them in a similar position to where they were.
Fantastic, thank you for that. So just picking up on the comment about going online, it probably doesn't apply to the current audience, but if you know retailers who are still yet to join that bandwagon, the webinar one was a presentation by Zealed and by Acronym, two companies that are leading this charge of assisting organizations to get online. So that may apply to you or to someone you know, and it's well worth taking a look back at that first webinar as to the comments that were made about how to get online fast, or perhaps ways to do that better. So thank you for those. Just a couple of questions stemming from what you have been talking about for the last almost an hour. The definition of a New Zealand-based retailer that is required for lease renegotiations, has there been any clarity about what makes a New Zealand-based retailer? Does the head office need to be in New Zealand? Or
I can answer that, and the answer is no. There's no clarity, because the cabinet minute just says that, it uses those words. So we're waiting for the legislation to see what we mean by New Zealand-based retailer. I should also say, what I was going to mention, the word fair legally is a very fraught phrase too. If you've said, I'm going to pay your purchase price that is fair, you can imagine arguing forever and a day. Fair legally is usually, you can describe a process as being fair, but it's usually hard to describe a financial outcome between two parties as being fair. So, I think this legislation is going to leave a lot of room for debate. And yes, who knows what a New Zealand-based business is.
So plenty of work to come for lawyers, I'm guessing.
Yes, with only $6,000 to arbitrate it. Yes, it smacks of the sort of leaky homes dispute resolution process. I think the threat of going to arbitration is probably more likely to force people to reach agreement than the actual arbitration process itself. Yeah, as it often does.
And the fact that at least is possible to start with a contribution towards those costs. Yeah, you're right. You also made comments, I'll leave the video focused on you so it won't keep switching to and fro. You made comments about the Australian regime, and it looked like you were more sympathetic to how that has been established, that it may be providing more beneficial outcomes. Is that a fair take? And do you see some convergence occurring potentially?
Yeah, certainly in my view, it is a fair assessment, Andrew. I think that the regime came out sooner, it provided more clarity, and it dealt with more circumstances than the current cabinet minute on the proposed restructuring. You know, the fact that it actually set a numeric bar, which is you must provide a minimum 50%, not 50%, a minimum 50% of rent-free during this lockdown period, and that it actually explicitly said that it applies for a reasonable recovery period thereafter. Those two things, I think, provide a lot more clarity. We've had a long period of time where there hasn't been clarity in New Zealand, despite the fact that it's been asked for. And a number of retail bodies had been lobbying the government for that, but for whatever reason, that it wasn't able to come to fruition.
I agree with that.
Fantastic. So I haven't seen any further questions coming through into the group chat. So I'll have the opportunity for anyone in the audience, if you wish to unmute yourself, now is an opportunity to ask any questions for Stephen or Connor. And in the absence of any of those, I will wrap up the session.
Great, thanks very much, Andrew.
Thank you.
Very good. Well, okay, so thank you both of you for your time this morning. It's been now this afternoon. It's been an awesome walkthrough of what the tools and the current circumstances are. And Connor, thank you very much for that that research insight. You had on your slide a link to the detail. I'll put that link up in the recording, in the comments to the YouTube recording. So if any of you have seen the previous webinars, I go away and process this video and put it up on YouTube. It should be there later this afternoon. And if you're looking for the link, it should be emailed out to you. But if you ever lose that link or wish to find any of the previous webinars, if you Google Massey University and Business Reboot, it should take you to the relevant page where all previous webinars, all 6 previous webinars are currently hosted. And some other webinars on related topics that have come from the COVID-19 period are also to be found there. You can also find them on Stuff's Prosper page, which they have set up to support SMEs. And so all previous webinar videos are located there as well. And thank you very much to Stuff for doing so. Normally, I would have a different background at this point to highlight next week's webinar, and there is indeed a webinar next week, number 9 and the last. But our fantastic partners at RetailX provide us with that imagery, and I've been remiss at getting that from them for today. So you just have to deal with this background at the moment. I hope to fix that for the recording later on. So next week, the last in the series, we're looking at perhaps a little bit more future orientation. So we have Bruce Howe from Putty talking about the strategy that retailers can consider for going online, and that's both websites and apps and other digital tools that are available. And we'll also hear from Greg Harford from Retail NZ, who opened the very first webinar, to what he sees for the outlook for retail in the next few years. So plenty more to come. Thank you both, Stephen and Connor. Fantastic hearing from you. And thank you everyone else for your participation in this and previous webinars. And go well, and hopefully we'll see you next week.